Okay, let's hit it, Mo. Just say when you need me to move those slides.
Well, good morning. I'm Mo Siegel here with my colleague Judy Siegel and our other colleague Stephanie Jashiva, who's listening in. And thanks to Faith and to the United Way for uh, having this presentation, allowing us to just chat with you about what we do at Pro Bono Partnership and talk about the top 10 legal issues for nonprofits. Judy and I will be tag teaming the presentation just to really highlight sort of the main issues that nonprofits need to focus on, and legal issues, focus on things that we might be able to address for you. This is our disclaimer on this slide. This is just general information. It does not constitute specific legal advice. It's what we lawyers need to say. And this is for educational purposes only. So I'm not even sure if we have images in this presentation, Judy, but
I don't. We have one or two, I think. It's all
okay.
good.
So let's go on. Just a little bit about, for the folks who are listening in or the ones who get the presentation afterwards, who we are. Pro Bono Partnership. We're a 501c3 organization in White Plains, now in our 26th year, which is hard to believe. And we're lawyers, and we provide free legal assistance to nonprofit organizations throughout the tri-state area, all in New York, exclusive of New York City, but all the areas around New York City: Westchester, Rockland, Putnam, Orange, Long Island, and also Connecticut and New Jersey. We don't help individuals. We help organizations themselves with the legal needs of your groups. Judy and Stephanie and myself are three of the, I think, 9 lawyers on staff of the partnership. We do some of the work ourselves, but principally we're a volunteer agency. We are recruiting lawyers from corporations and law firms who are in the communities. They take projects through us to help our nonprofit clients. So,
and I just want to make clear to everyone who's listening that when we take these volunteers, we have an entire staff that screens to make sure the volunteers are really only going to be working in their areas of expertise. So we are very, very, very protective of our clients. So for example, if you're a real estate lawyer but want to learn how to be an employment lawyer, that's not going to work for us. You need to have that specific expertise to work on our clients' matters. So if you need help with an employment matter, you're getting an employment lawyer. Similarly for any other type of issue you have. So fear not. We are very protective of our clients.
So our clients are nonprofit tax exempt groups, or in some cases, people who want to form a nonprofit tax exempt organizations that are in our geographic area, serving the poor and disadvantaged, providing important social services. We work with a wide range of nonprofits. We don't help religious organizations, but we help groups that are working in the arts, working in the health field, working in education, really groups that are doing, tremendous work in our communities and that do not have the ability to pay for legal services without impairments to your program. We're not helping large nonprofits, hospitals, and universities that can pay for lawyers. But we're helping groups that wouldn't be able to pay without impairment. Next slide, Judy. We help with business legal needs for nonprofits, so not litigation projects. We say if you're getting sued, don't call us. But if you want to be proactive in addressing legal needs, we're here to help you in the areas of corporate governance, looking at bylaws. And this is some of the things we're going to go over in the presentation, looking at bylaws, conflict of interest policies, certificates of incorporation, reviewing contracts, employment law issues, intellectual property law. Again, we're going to touch upon these things in the presentation. Real estate, looking at leases, buying property, leasing property, regulatory compliance. It's the day-to-day things that come up for any business. And we help address those so you can be proactive and better concentrate on your mission.
Right. And Mo's also forgetting the last line, which is if you're not a Pro Bono Partnership client, but want to become one, please go to our website. The link is in the slides, or if you go to our website, it's the second tab from the right on the very, very top of our homepage. You would click on Request Legal Assistance. We ask you to answer a few brief questions and then upload some documents. If you're an existing nonprofit, we want your last 990. We want your bylaws, your conflict of interest policy, your operating budget, and your list of directors. Really super easy. And then one of our attorneys will call you, or our wonderful admin, Kira, will reach out to you. We'll schedule a screening meeting where we'll talk about what you think your legal needs are, what we think your legal needs are. We'll talk about our process, and we'll get you rolling if you qualify. but let us decide if you qualify. Don't eliminate yourself before you reach out to one of us.
I'll turn it over to Judy in a second. Just two other services that we offer for nonprofits. Even if you're not a client, you have a general legal question, call us. We have a resource call hotline. We'll try to answer general questions for anybody who contacts us. We also offer a whole host of webinars and seminars, legal alerts. Clients or not, you're welcome to take part in those. And if you look on our website, you'll see a whole list of presentations that we're going to be giving, similar to this one, and some that are some more in depth. If you sign up on our mailing list, you'll start getting emails of those in your inbox. So please use this as a resource to help strengthen your organization. All right, Judy.
Okay, so we're going to get started just making sure that everyone's on the same page. We're going to talk a little bit about verbiage, believe it or not, nomenclature. So what you need to understand is that there is a very distinct difference between being a nonprofit or a not-for-profit, same thing, we'll use those two words interchangeably, and being tax exempt. So being a nonprofit means you have been created as a legal entity, as a form of corporation under New York law. So if you're a not-for-profit corporation, you actually have been incorporated under the not-for-profit corporation law. Exactly the same type of process as if you were doing a for-profit business. If you were starting a limited liability corporation, you would use the LLC law, the limited liability corporation law. So first thing to remember is nonprofits are creatures of state law. You're created under a body of law that's state-driven and that controls you. So that is our key takeaway on being a nonprofit. Nonprofits do not have to be tax exempt. And in fact, many of the clients who come to us are not tax exempt. Tax exempt is a federal denomination. It is given to you by the Internal Revenue Service. It is a tax code section. And in fact, 501c3 is singular shorthand language for having been blessed by the Internal Revenue Service under Section 501c3 of the Internal Revenue Code. In fact, there are 29 subdivisions under C, but everyone really likes the 501c3 one. It's like the golden ticket from Willy Wonka and the Chocolate Factory because it lets donors deduct their deductions, the value of those deductions on their own tax return. So 501c3 is our Willy Wonka moment. As the slide says, 501c3s are organized and operated exclusively for purposes that are charitable or literary or educational or religious. It's what you think of when you think of a nonprofit or a tax-exempt entity. But again, you can be a nonprofit. And in fact, once you're created under the laws of your state, whatever state that is, New Jersey, Connecticut, New York, you are a functioning nonprofit corporation, and you have to follow the laws of your state. So remember, big distinction, nonprofit, state law designation, talks about how you were formed and which laws you follow. Tax exempt means the IRS has blessed you and you get certain tax benefits and advantages. Now, the other thing I want to just touch on briefly is the structure of a nonprofit. And this is not just for New York State, pretty much in all 50 states. If Mo and I were better at PowerPoint, which I'm going to say you're not going to teach these old dogs new tricks, this would be a flow chart that had downward pointing arrows between the boxes. But remember, top-down model, and it starts with the members, which we'll talk about in a minute. The members elect the directors or trustees, call them what you will, who then hire and supervise an executive director if there is a paid for senior staff level executive director position. And then the executive director hires and or supervises everybody else, both paid staff and unpaid or volunteers. So the top box is where a lot of our clients get confused when we talk about members. So for example, the United Way, going to use you as an example, Faith, used to be a membership organization in the true sense of the word. In New York State, you can have two kinds of members, capital M members, and those are members that have legal fiduciary duties and responsibilities to the organization. They have tasks that they must do, like electing the directors of the board that oversee the nonprofit. So that is a capital M member, really important. They have responsibilities and these legal fiduciary obligations. and that is actually the minority in New York State. You find very few capital M membership organizations, but we did see them in United Ways. YW and YMCAs have capital M structures oftentimes. Statewide organizations. I'm sorry, what, Mo?
Daycare centers sometimes.
Daycare centers, absolutely, because the families want to have a say in who's running the organization. And we also see it in statewide or national organizations where the members, which are like, if we're looking at a statewide organization, if there's a member from every county, they want to have a say about who's running that statewide organization. Those are capital M members. Now contrast that with a lowercase m member. And those are people whose values or goals are aligned with what the nonprofit does, but those members do not have corporate or fiduciary responsibility or obligations or rights, but they can still have to pay dues. When my kids were little, we were members of the Bronx Zoo, so we got our free parking passes. We got 10% off at the gift shop, which was the bane of my existence. But we were in no way, shape, or form electing anybody to the board of the World Wildlife Conservation Fund. So that's the difference between capital M members and lowercase m members. And we absolutely encourage you to have members who show their support through membership dues, but just be clear in your governance documents, and you should be checking your governance documents at least once a year. So your bylaws, your certificate of incorporation, to see whether you have capital M members if you have members or lowercase m members, and run yourself accordingly. And really happy to talk about that offline with any of you who have questions. All right, so how do we apply to get a 501c3 status? You apply to the IRS. It's either a short form or a long form. The IRS is woefully understaffed, especially in the exempt org department. So there's like a 9 to 12 month delay on getting any processing going. But there are pros and cons of becoming a 501c3. As you can see through the slide, and as we talked about, 501c3 is that golden ticket. Your donors can deduct the value of their contributions to you, and we'll talk about how to acknowledge that a little later on. You may also be eligible from state income or sales taxes and possibly from property taxes. That property tax exemption is not automatic, so we can talk about that offline also if you have any questions. Some of you may have heard the word pilot kicked around. That means payment in lieu of taxes. Some municipalities, Yonkers, for example, are beginning to implement pilot programs with nonprofits rather than give them a complete pass on taxes. I believe Yonkers is sort of negotiating these pilot payments. Happy to chat with you about that. But there are negatives or trade-offs, a better way to put it, of getting your 501c3 status. You are not allowed to have private benefit or annulment. Basically, that means you can't use the nonprofit for your own personal benefit. We can talk about that in detail, and we do at some of our other workshops. There's a restriction on lobbying activities. Lobbying is supporting or opposing a specific piece of legislation. There are various ways to approach how much lobbying you can do. If you have questions about that, again, feel free to call me, Mo, or Stephanie. And finally, and this one is a hard no, hard line in the sand, you cannot engage in any political activity, and that means supporting or opposing a political candidate. I am sure we will be getting questions about this probably sooner than we would like, even though it is now January 2023. I have no doubt that our nonprofits will start ramping up. So please feel free to reach out to any of us about political activity and lobbying. Which gets us to corporate governance, a topic near and dear to my heart. I spend most of my days working with our clients on corporate governance. So we start off with, if you're in New York State, well, actually in any state, but in New York State, every single board member has 3 fiduciary duties: duty of care, duty of loyalty, and duty of obedience. I'm going to start by saying this is something that we lecture on all the time for things like an hour or an hour and a half at a time. I'm actually doing a workshop next month, I think on February 15th, on building your best board and running your best meeting. Feel free to sign up. We spend about the first 45 minutes of that presentation discussing what these duties require both legally and practically, so that you know what you're asking a new board member to do. But in the super highest level discussion of it, Duty of care means taking care of the nonprofit and really being engaged in the work of governance and leadership of the nonprofit. Duty of loyalty, super easy, actually. You always have to put the best interest of the nonprofit ahead of your own. Seems kind of obvious on that one. And finally, the duty of obedience is a very quirky one, particularly in New York State. It's both inward looking and outward looking. It requires the board member and the board as a whole to make sure that the nonprofit internally is following its own policies and procedures, its own set of bylaws and governing rules. And externally, it requires the board to make sure that they're fulfilling all of their outward obligations, proper registration, proper tax filings, filing any laws, policies, requirements. So at the highest level, that's fiduciary duty of care. Managing conflicts of interest, got another workshop on that one coming up, probably, I think it's scheduled for May or June. New York State legally requires a conflict of interest policy. Our clients call us all the time. Oh my gosh, there's a conflict of interest. There's a transaction we're thinking of entering into, and it's with a board member or an officer or director or what's considered a key person, which totally call me if you want to talk about that. There's a whole long discussion about who is a key person. But the point I want you all to understand is conflict of interest transactions, or related party transactions, as they're called in New York, are not per se banned. You have to do a very careful analysis. You have to document it in a very specific, detailed way. But if at the end of the day, the transaction is in the best interest of the nonprofit, and I think pretty much anyone who's on this call knows that nonprofits run on related party transactions, do it. If it's in the best interest of your nonprofit, just make sure you've analyzed it and documented it appropriately. When we talk about bylaws, that you have to make sure they're legally compliant. There are a whole host of requirements in New York State. We're pretty heavily regulated, but equally as important is Stephanie and Mo and I can write you the most perfect set of bylaws, but if you're not following them, that's where the trouble lies, because you've breached your duty of care. So if it says you're going to have a board meeting the first Tuesday of every month, and then you suddenly start having those on Wednesday, I mean, I applaud you for having the monthly board meeting, but you've breached your duty of care because you're not following your bylaws. So please review those bylaws and make sure you're following them. And then in terms of other corporate governance policies, some are mandated. If you have even one part-time employee, you must have an anti-sexual harassment policy and you must do specific training. You must have a whistleblower policy in certain conditions. Others, like record retention policy or gift acceptance policy, are up to you. Again, that's something that Mo, Stephanie, and I counsel on a lot. So please feel free to use us. All right. Now we get to registration and filings. Let me just say, in New York State, there are lots of ways you have to file. Every nonprofit in New York State is required to register with the Charities Bureau of the New York State Attorney General's office. Mo and I were just discussing before this call how the AG's office will be doing another presentation on how to register with them. Super easy these days. It's all online. You would have to register in one of two ways, or because of one of two ways, or perhaps you're a dual registrant because you fit both buckets. The first is under New York State executive law, and that's if you solicit or collect funds in New York State. And the other is the estate, practice, and trust law, which requires you to register with the AG if you've been incorporated under New York State law, or you're doing business or holding property here. So basically, you're going to have to register. There are certain exemptions. We can talk about those if you have any questions, but please remember there's an annual registration requirement for the most part with the AG's office. We put IRS Form 990. That's basically a nonprofit tax return. Failure to file it for 3 consecutive years means you will automatically, because it's computer generated, lose your 501c3 status. Don't do that. File your 990s. If you're doing business in other states, we see this all the time, especially here in Westchester. If you're operating and providing your great services in New Jersey, if you're a Rockland nonprofit, or if you're a New York nonprofit and you're perhaps working and providing services in Connecticut, you probably have to register in those states as well. So please be mindful of the fact that just because you're incorporated or doing the bulk of your work in New York State doesn't mean that you're not working in other states and may have to register there. And then finally, the disclosure requirements on the 1023, which is your actual application to the IRS for your 501c3 status or your 990 needs to be updated, and you need to stay within the parameters set on those documents. Again, we could talk about that for quite some time. Feel free to call one of us if you have questions. Fundraising.
Let me just jump in on one thing here. The difference on the last slide about registering in other states, that's whether you're doing business in another state, not whether you're fundraising in another state, which Judy's about to talk about.
Right.
So
There, you may be required to register because you're doing business there. You have an office there. Now, in the days of remote work, if you have an employee who lives in Connecticut, but you're a New York State nonprofit, they're getting paid there, they're working from their home, you should be talking to your accountant about whether or not that's considered doing business and whether or not you need to, well, you can be talking to us about whether you need to register there, but really this is totally, remote work has totally expanded this requirement for registration in other states. And we tell our clients all the time in the context of employee decision-making, you can let your employees work remotely, but understand there may be a whole host of legal ramifications for doing that once that person is in another state. All right,
even if
fundraising.
you're doing all your work in New York, but you're fundraising in another state, that's what Judy's going to talk about, different registration.
Right. So we're going to start off with properly acknowledging the donations and contributions you get. Technically, if the cash contribution to you is less than $250, you don't have to acknowledge it. Heidi, our head of development's head would explode if she ever heard us make that statement, because she would say good donor relations require you to acknowledge every donation. But technically, $250 is the IRS's legal requirement for a donation of cash. What becomes a bigger issue for our clients is someone donates 10 computers to you, and the donor wants you to say it's valued at $10,000. The answer from us legally is you do not acknowledge the value of a good given to you. You recognize the description of what that good is, but you do not place a dollar value on it. There's a really big distinction there, so please remember that. So if you're getting a good, you only acknowledge receipt of that actual item. Similarly, if someone says, oh, I volunteered with you, I need an acknowledgement because I'm a lawyer and I get billed at $500 an hour and I spent 10 hours working for you, so can I please have an acknowledgement letter for $5,000? The answer is, unfortunately, no. People don't get to deduct the value of their services to you. So that's another thing just to keep in mind. Now, commercial co-ventures is a fancy New York State legal term for when a for-profit business who works regularly or primarily engaged in that trade or business advertises that use of goods or services is going to be beneficial to a nonprofit. So there are a couple of things that go with this. So the easier thing to do is to explain it to you. So if Mike's Deli says, hey, in February, we're going to give you 10% of the profits, and we'll say, you know, February is ABC nonprofit month. Great, we say, always happy that our clients are having another source of earned income. We love that. But you should know, first of all, you're going to have to report that income out separately to the New York State Attorney General's office on your annual filing. So please book it separately. And you really should have some form of contract. You want some kind of agreement that spells out the relationship. For example, I said 10% of profit. Is that gross profit? Is that net profit? Is that only profit off of sandwiches? Who knows? But you want to define that relationship. And we're going to talk a little bit more about that later on when we talk about contracts, but that's really important. The other thing, and it ties into a question that Faith sent to us earlier, is you want to control the use of your intellectual property. So you have a reputation in the community. People associate, you know, ABC nonprofit doing great work. And, you know, when we hear your name, it makes us want to do things. Well, that has value and you want to protect that. So you want to have some control over how Mike's Deli uses your name, your logo, your intellectual property, which includes your goodwill. That would also be an agreement. Stephanie Moe and I knock those out all the time. So come talk to us about that. But please remember, those kind of relationships require some special language and some special reporting to the Attorney General's office. And again, because one of you is going to follow up with this question to me, I have no doubt. Well, what if the fire station wants to sell t-shirts? Well, I'm going to say the fire station is not a for-profit business that's regularly and primarily engaged in the sale of t-shirts. So, you know, go with grace and not a commercial co-venture, but happy to talk with any of you about those distinctions. Multi-state solicitation requirements. This is something we lecture on forever. I'm going to refer you to our website and our learning center, and you can look at on-demand workshops and webinars, because our colleague from New Jersey, Allie, did a fantastic 1-hour workshop on multi-state fundraising. Highly recommend it. But I will say in general, if you are actively soliciting in other states, you send out a newsletter, even electronically, that asks for money. You send a thank you note to a donor from North Dakota. And in that thank you note, you said, and hey, we hope you make further donations to us. That is a solicitation in another state. But one time, one hit in another state is not enough to really require you to have to register in another state. Most states have either dollar limits. If you solicit or receive less than X amount of money, go with grace. The other thing I will say is, for clients that are really actively soliciting in other states, I often suggest, we go back to 3rd grade and the pie chart. And I tell my clients, well, why don't you make a chart and do 2 of them? One's going to show by state the percentage of dollar values coming in from those other states. So if you see that you get a lot of money from Florida, because that's where everyone's grandparents go in the winter and they make those donations, then maybe you need to register in Florida, which is a really active go get them kind of state anyhow. But if you only get one donation from North Dakota, there's not enough contact or touching with that state for them to have jurisdiction over you. The other pie chart you're going to want to make is comparing number of donations, because if you get the vast bulk of your donations from North Dakota, even if they're a tiny dollar value, then you're going to want to think about registering in North Dakota. Again, going to refer you to our website, our learning center. There's a wonderful 50-state analysis of the requirements of when you would or would not have to register in each of the states. So that's another great tool for you. Our nonprofits often want to have charitable gamings, raffles, bingos, etc. Believe it or not, that's not the AG's concern. That's the New York State Gaming Commission. The rules have been loosened up somewhat, especially around raffles. But please remember, you can't be doing this over the internet, and people under the age of 18 are legally not allowed to be selling raffle tickets. So all those baseball and Little League and all those basketball tournament raffle tickets, technically not allowed. And then finally, required language for solicitation. New York State's pretty specific about it. At a minimum, you have to be able to say on any solicitation material that the donor can obtain your most recent financial statement from either the AG or you. You got to put some bold language on in big bold print and big font. If you have questions, reach out to any of the 3 of us. We're happy to help you with that as well. All right, and now we get to Mo with the bulk of all our clients' issues who have employees.
So again, the idea, thank you, Judy, is hopefully this is just helping you sensitize you and your organization to issues where you can come to us or another lawyer and address things if you think they're an issue. But far and away, the biggest area of work that we do is in the employment realm. Probably close to 1/3 of the projects we handle for nonprofits are employment related. So much so that 2 of the lawyers on our staff are employment lawyers, and they handle almost exclusively or a very substantial part of their work is in the employment realm. The same employment laws that apply to for-profits apply to nonprofits. So you don't get a pass as a nonprofit organization. Your biggest potential source of liability or lawsuits against your organization would be employment-related suits. That's why we think you need to be hyper-vigilant when it comes to employment-related issues. And employment laws are changing all the time. So we have this wonderful colleague, Jen Grodnowski, some of you may have worked with, who's always keeping up with changes in the law. We're putting out announcements all the time on new changes on the law. So you might have, in the next slide, we talk about personnel policies that you haven't had reviewed in several years. You should really review, we'll get to that in a second, but really review them regularly to make sure they have the latest and greatest information in them.
And Mo, can I just interrupt for a minute to remind everybody that even if you're not a PPP client, you can always email in and ask to be put on our mailing list, and then you'll be getting the legal alerts that Jen writes about employment law, that Stephanie, Mo, and I write about not-for-profit law and contract law, and you'll get these legal alerts when the law changes, which always have next steps. What should the nonprofit do? So please take advantage of that.
One of the things you want to know is if you are an employer at will, as many employers are, nonprofit and for-profits, which mean you hire people without any sort of a contract, and they could be hired or fired for any reason or no reason, as long as it's not an illegal or a discriminatory reason. That gives flexibility to the employer, but it doesn't mean you can just do anything you want to without repercussions. So you really want to know what employment at will means,
And
and
the
you're following the rules.
And the flip side of that would be, and Jen would want us to say, Mo, that this means you do not have to. And in fact, we generally advise against giving an employee an employment contract, because then you're bound by the terms. Employment at will, you can give an offer letter, and you might want to give an offer letter, but you don't want to be giving an employment contract except for some very limited circumstances. So please remember, if you give an employment contract, you have now locked yourself in a way that's not legally required.
And without getting too much into the weeds, because we could talk about this for hours, you could say something to an employee which could be construed as an oral contract. If you do so and so, you'll be here forever. You'll have permanent employment, even if it's not in writing. You might have locked yourself into, or at least an argument from the employee that they have a contract. So let's go on, because we want to be mindful of time. Do you have personnel policies? If you have employees, you should have personnel policies. Are they up to date? Are you scrupulously following them? Have they been reviewed by legal counsel who has employment expertise on a regular basis? That doesn't mean every month, but every year, every 2 years, to make sure that they are compliant with employment laws. I would say, and we'll see if Judy and Stephanie agree with me, while you should certainly follow your bylaws and other policies, you really want to follow your personnel policies.
100%. And I will say, failure to file them, again, is a breach of your fiduciary duty of care. And to put it in some context for you, when Letitia James, the Attorney General, sued the NRA, the National Rifle Association, the vast bulk of her causes of action, or the reason she was suing, was because they had really great policies in place, but they didn't follow them. So it wasn't they didn't have them, it was the failure to file their own policies. So breach of duty of care and of obedience, as we spoke about.
Judy, let's move on. So a couple of issues that are high level ones that come up a lot for nonprofit employers: the classification of people that are working for your nonprofit. One is an employee versus an independent contractor. Is an employee where you're supposed to withhold taxes, versus an independent contractor with somebody that might have other people they work for. You do not withhold taxes for them. You might have a contract with them, an independent contractor agreement, not an employment agreement. Many nonprofits mischaracterize the people who work for them as independent contractors because it might be less expensive for the nonprofit to call them that, but they really might be an employee. And somebody's not an independent contractor just because you call them one, or even if just because they call themselves one. You need to analyze the relationship with the person, how much work they're doing for you, where they're doing the work, whose tools they're using, how much control you have over them. It's an analysis. So you want to make sure you're properly classifying people as a contractor or as an employee. Then if somebody is an employee, are they exempt or non-exempt from the Fair Labor Standards Act that has certain requirements for things such as overtime and how much you have to pay folks. If you are and this is a broad generalization, if you are an exempt employee like Stephanie and Judy and myself, we can work as many hours as we need to, and we do, in order to get the job done. If somebody is a non-exempt employee, so they're subject to the Fair Labor Standards Act, you must pay them overtime if they work over 40 hours. So there are some nonprofits that will mischaracterize people as exempt employees, say because they want to avoid having to pay overtime, and it's an incorrect classification. So make sure you are properly classifying the people that you're working for. Have job descriptions. The job descriptions will be a very big driver in what the classification of the employee should be. And the employee's classification could change depending on their responsibilities as their work goes on from, say, a non-exempt to an exempt employee. So,
and I would also say,
go ahead, Jude.
Mo, you and I and Stephanie are very experienced, and we all reach out either to Jen internally or to the whole host of employment lawyers that we work with, because it is such a nuanced, complex analysis. And if you get it wrong, the Department of Labor, both state and federal, they don't play. They really are all about the fines and penalties. So this is an area we really urge you to come talk to a lawyer about.
Let's move on to the next slide. We want to make sure that we get through everything in our time. Nope, go back one slide, Judy.
There you go.
Have good hiring practices. Are you giving offer letters that say in particular that this is not a contract of employment? Are you using the same good non-discriminatory hiring practices as you do when you oversee someone who's working for you? Are you giving the correct, do you understand what the accommodations that you have to give for disability or for religious belief or a whole host of other accommodations that you need to give your employees? Do you understand state and federal family medical leave laws and other leaves of absence laws? Again, these are things that change all the time. That's why you want to stay on top of them. Do you have good performance management techniques with your employers? Are you regularly reviewing and talking to your employees about any issues that may come up? Do you conduct performance reviews? Our employment colleagues will say, you shouldn't just do an employment review of somebody one time a year. You should be giving them regular feedback throughout the year about how they're doing. Are you documenting poor performance? And then we'll move on in a second. We get so many calls of pro bono partnership for a frantic nonprofit employer that wants to terminate somebody for something. And they'll say, well, the person hasn't, been working well. We'll say, well, what is their, have you been evaluated them? What do their evaluations say? And their evaluations might be generic or they might be fine. Well, even if you have the right to let them go, if you don't have good documentation, you're going to get a challenge about the termination, or the circumstances may be such that even if they're doing having poor performance, it might not be the right time for you from a risk management standpoint to let them go. Somebody just comes back from a disability, for example, or from pregnancy leave or something, where the circumstances would be such that you're letting them go and they would say, well, it's really a pretext. You weren't letting me go because of my performance. It was because of something else that, where you're not allowed to let me go. So,
And just, Mo, before we move on, which I'll do in one quick second, in terms of accommodations, the lawyers at Jackson Lewis, a law firm that only specializes in employment law, are doing a whole workshop for us in 2 weeks on accommodations. Very complex topic. They're wonderful speakers, so we encourage you to go to our website and sign up for that.
let's move on.
I did.
Volunteers. We all use volunteers, or most of us use volunteers. We are a volunteer-driven organization. We have some in-office volunteers. I'm sure most people listening to this, it's the same way. Are you properly classifying your volunteers as opposed to not being employees? Are you giving them any form of compensation at all, which could somehow turn them into an employee? You want to be careful about what it is you're giving to your volunteer so they can't make the argument that, no, we're really an employee. Do you give them any kind of benefits? Do you give them any financial compensation? Or do you just give them gifts or a meal? You have to be careful. Are you properly screening volunteers? So many nonprofits, we're so hungry to get volunteers that you might take in anybody who expresses an interest, which is great, but you want to properly screen them so that you're protecting your organization, you're protecting the volunteer, and you're protecting your clients. And I think a very, very general rule of thumb is the more risk there might be for a volunteer position, the more detailed you want to be in the screening of them. So if you have a volunteer who is personing a table at a 5K run, for example, and just taking registrations when there are 500 people around, you might need to do less screening of that volunteer than someone who's working with the elderly or with the disabled or with children in a private setting where there's more risk of potential harm to your clients.
And Mo, I do just want to throw out that if you're going to do background checks on your volunteers, you don't want to be doing them yourself. You want to be hiring an agency to do it, to make sure that you're not looking at anything that you're not legally allowed to look at or permitted to look at, because oftentimes our clients do them themselves. Then they make a decision based on something they're not legally allowed to do. And if you use a third-party provider, it shields you from all liability. And those third-party providers also generally have access to far greater databases than you will.
Do you have releases that you use with the volunteers? We spend a lot of time in Pro Bono Partnership for Nonprofits drafting releases for volunteers, drafting releases for parents and programs for their children. They are a form of risk management. And we're going to be giving a seminar with Nonprofit Westchester in March on insurance and risk management. We urge you to, I think it's March 16th, to attend that. Do you have insurance? Which a topic in and of itself, which not only covers volunteers, but do you, as far as a risk management technique, do you have the right insurance policies for your organization that governs the risks of your organization. We'll say to some clients, well, do you have insurance? They'll say yes, but they don't even know what the insurance is for. They just know they pay a policy. Do you have employment practices insurance? Do you have insurance that covers volunteers? We have malpractice insurance that covers our volunteers. So you want to talk to an insurance professional to make sure you're properly insured. Go on, Judy. Just jumping topics, because we just really want to highlight things you want to be aware of. Intellectual property, which Judy had mentioned before. We do a fair amount of intellectual property. Nonprofits have valuable intellectual property as for-profits that you might want to protect. You have a name, you have a logo, you use pictures, you might put things up on your website, in your marketing materials, on your social media. You create content. You might have internal policies or other materials that you create. You want to protect those things. In particular, names and logos. We have intellectual property lawyers who do a lot of this. They'll look at your name, they'll look at your logo, they'll say, well, what kind of logo can you put on the name and logo or mark to make sure that you're protecting it? Do you want to file with the U.S. Patent and Trademark Office? You have the right to do so, depending on where you're doing your work, to protect that. Using your name and logo. Are you using somebody else's name and logo? We've had clients that have gotten these, what I call McNasty letters from other nonprofits or for-profits saying, we have a protection in this name. You're using the name. We're going to try to get money from you for you using our name. So you don't want to use a name or a logo unless you're sure you have the right to do so. Judy, you were going to say something?
Yeah, I just wanted to point out to everyone who's listening that we're going to have 2 specific workshops about intellectual property. We have one in April on copyright law, protecting your good, like the content you've created, and explaining what of other people's you can use and how you might be able to use it. That's with a lawyer named Terry McAllister, who's an intellectual property attorney. He'll be doing that on April 19th. And then my colleague Stephanie is overseeing a webinar that's going to be given for us by Alyssa Hecker, a phenomenal Westchester County intellectual property lawyer. And that's going to be sort of covering everything on the slide. So it's going to be just general intellectual property. It's an area that we're doing 2 workshops on because we feel very strongly that our clients get it wrong. And we're working really hard to make sure that you don't. So please be on the lookout for those.
So I want to get through the material. So let's move on from here. E-commerce and internet. We all have websites. We didn't when we started a pro bono partnership, but everybody has a website now. Have you had your website reviewed by an attorney? We'll get lawyers to do what we call legal audits of your websites. Do you have a terms of use policy on your website, which you should? Do you have a privacy policy on your website, which you should? Do you use pictures on your website? And do you have the permission to use those pictures? Do you have contracts with web developers? Who owns your domain name? You want to see if you have the right to make sure that you own that name and the materials that are created on your website. We said before, permission to use materials on website and social media. Besides websites, we're all using various forms of social media. And do you have the right to use pictures? Do you take pictures of clients, for example, that you might use on your website and social media? And do you have permission from them to use their likenesses? Are you collecting information on a website? Are you collecting client information? Are you collecting credit card information? Are you protecting information that you are collecting? You want to be attuned to these issues to make sure you're doing them properly. Judy, go on.
I'm there.
Go ahead.
No, I'm there. We're
Okay.
good. So let me just ask, Faith, we started a minute or 2 late. Can we run to 9:35 just to make sure we get all the points out to everyone who's listening?
I'm making that happen.
Okay.
Other than, in addition to collecting information on a website, what kind of information are you collecting from volunteers, from donors, from your clients? And are you protecting confidential information from your employees? It's the whole issue of privacy concerns. You want to make sure you're properly collecting and storing and maintaining information. Do you collect health information? Are you governed by what's called HIPAA? And do you have to, if you're governed by HIPAA, are you properly collecting and storing health information of, say, particularly your clients?
Hey, Mo, but on this one, I want to be really clear. far fewer of our clients are HIPAA driven than they think they are. So we have a lot of clients who inadvertently take on these quite odious requirements of HIPAA, and have, once they take them on in their own legal documents, in their policies, procedures, they're now legally obligated to do it. Whereas if they had consulted with a lawyer, we would have said, glad you're thinking about it, but this does not apply to you. So you do not need to take on these, these extra duties. But once you say you're doing it, again, you've got to follow your policy. So if you said we're going to do it, you have to do it, even if you weren't legally required to.
Social media use by employees is really is related to the employment questions. Do you have policies in place about your employees using your nonprofit's social media? Who can post on your social media? What can they post on their own social media? Policies making sure that they're not disclosing confidential nonprofit information on their own social media. Judy, let's move on. So we're raising all sorts of things where you want to be attuned to these things and having them addressed. Judy, you're next.
Yep. And if you would need, as we speak, if something, sets off a light bulb with you, please remember, you can apply to be a PBP client. If you want some more general discourse about it, you can call us as a resource call. Please use us as that resource. So in terms of real estate, leases are legal documents that spell out your rights and responsibilities. So you have to be attuned to what they require. Let's say you want to leave your lease. You may have to give a certain number of days notice. So if you have a great new lease or a great new opportunity and you want to be done in 30 days, that's great. But if your lease requires 90 days notice, you have to follow that or you're in breach of this legal document and you can be sued. Or you may have other obligations if you fail to follow it. Flip side of that, though, is the landlord may have obligations. Is the landlord obligated to give you a certain number of days notice if he or she wants to boot you out of that space? What are you going to get if you get booted? We've had one client who got kicked out and at first was panicked, but then when we went back and read the lease, the landlord was required to give them level AA, same space in a level AA building, and they were in a less good building. So it was very beneficial, but they wouldn't have known that unless we had, parsed through that real estate lease. So important to understand what that lease says and what you're binding yourself to. Similarly, in terms of understanding the terms, are you responsible for some or all of the taxes, any common area maintenance charges, things like snow removal, utilities? How about number of parking spaces? Have you negotiated that they're supposed to be repainting your space every 2 years? You've been in there for 10 years and no one's put a paintbrush to a wall. This document should be spelling out everything you want. So please think broadly.
Here's a takeaway, generally speaking, from everything that we're talking about. Talk to a lawyer before you sign a contract.
Oh,
a lease
please.
is a contract. We can't tell you how many clients come to us after they've signed something and they want to know what it means or what their responsibilities are. Whether it's pro bono partnership or another lawyer, talk to somebody, make sure you understand the terms of a contract or a lease before you enter into it.
Right. And please also remember the point here is that pretty much anything is potentially negotiable. Are we going to promise you we can negotiate you that you're not paying the bump up in taxes or you're going to get 7 parking spots instead of 6? No, but we can promise you 2 things. 1, if you don't ask, you're never going to get it. And 2, as one of our clients said to us years ago, which I've always loved this, I used to be the David in the real estate, the landlord used to be the Goliath, but once we had PBP on our side, I became the Goliath. So remember, we can be your Goliath in any kind of negotiation. Which gets us to our next point, corporate changes. So there are all kinds of forms of corporate changes. You can collaborate with another organization. You can jointly run a program. You can do a joint venture where 2 entities get together and create a 3rd entity. You can refer a program that you've been running to another organization and you'll have some kind of written agreement between and among you, depending on how many people. You can have a shared service agreement, which we were speaking with Faith about earlier. That might be an agreement where a larger nonprofit says, hey, I have a full back office staff. It does my HR, it does accounting, it does whatever back office staff does. And smaller nonprofit needs some help. So they go and say to bigger nonprofit, can we enter into some kind of written agreement with you where you handle all of those for us? And the answer is yes, you can negotiate that and we can help you with that. You may want to form a subsidiary. Let's say that you've come up with an idea for an earned income revenue stream. Well, depending on how you're structured and what your finances look like, you may want to set up a for-profit business. there are certain legal requirements around that, both in terms of New York State, what you would have to do, and what you would have to do to maintain your 501c3 status. It's doable, but legally complex. We can help you with that, but you should be seeking legal counsel to make sure that you do it properly, so you don't lose your 501c3 status, so you're paying the least amount of sales of income tax possible. Things to think about. Mergers. We were speaking about this earlier before the call started. There are lots of potential mergers out there, and they tend to fall apart. Why? Because the entities don't actually understand what it means. Mergers, 2 entities, the end of the day, only one is left standing, only one maintains its identity. It's one board of directors. You need to understand what's going on there. Now, I will say with a merger, assets and liabilities transfer. That may not be beneficial. You may only want to do an asset transfer, a purchase. Again, we have corporate lawyers, M&A, mergers and acquisition lawyers, who do this in like $100 million transactions, but they're equally happy to do, actually, I would say they're probably happier to do it for our nonprofit clients. So if you're contemplating this, there are a lot of thought, a lot of decision-making, a lot of due diligence that goes into it. Again, talk to us about it. And finally, dissolution, because sometimes the life cycle of your nonprofit has ended. Whole process and procedure in New York State. Let us walk you through it and do it with you so you get it done right. And then, because it's bonus day, one last thing, contracts. So contracts sets out your legal obligations. It's not just for when things go wrong. Look at a wedding contract. You can negotiate the number of people parking cars. You can talk about how many servers are going to be serving the food. Do you get the bridal suite? Is it included, or do you have to pay extra? What about hours? Your party's from 7 to 11, but it's such a rockin' party you want to stay even longer. How much is that extra hour going to cost you? Contracts need to embody every part of the understanding between the two parties, because at the end of the day, it's what governs. It doesn't matter what you said, it matters what you put down in ink. Really important. You also have to understand your obligations, your rights, and your responsibilities. Again, you can look at a notice provision. You can look at cancellation policies, which is really where the rubber hits the road for a lot of our clients. Again, looking at that wedding contract. What if they get a better offer? Can they kick you out? Well, let's say they can cancel you. Do they have to give you 10 dates to choose from? Do they get to choose the date of when they're rescheduling you? Do they have to refund your money in whole or in part? I say this because a number of the kids who work for us are getting married. So I've looked at a lot of event contracts for them lately, which has been great. But my point is, there were all kinds of things in those contracts that they had no idea about because they didn't read all the fine print or understand what that fine print meant. So again, please come to us. And our last slide is, it's just going to give you our contact information. We could put Stephanie up there too. Sorry, we didn't add you, Steph, but if you reach out to one of us, we can also connect you with Stephanie. And I want to thank Faith and the United Way for giving us this great opportunity, and really encourage all of you to reach out to us if there's anything we can do for you.
Please do. We want to be a resource to the Westchester nonprofit community. We've been proud to be in Westchester for over 25 years.
And quick shout out to Janai, my client, who I'm always happy to see your smiling face. And you too, Nikki.
Thank you guys so much. This has been so informative. I have questions that we need to have, especially because we have our large essential goods program. So when we were talking about values, but I think this was a fabulous workshop. So thank you so much for you guys coming.
Thank you.
Thanks for the opportunity. Talk to y'all soon. Bye-bye.